I would like to note for the record that today is Wednesday, February 27th, 2019, and that this hearing is taking place at the Office of the U.S. Trade Representative, or USTR. We will make a transcript of today's hearing available to the public on USTR's website. Today's hearing is scheduled to go until approximately 3:30, and we will break for 1 hour between 12:20 and 1:20. I would like to ask for everyone's cooperation with keeping the hearing on track. At this point, I would like to ask colleagues on the hearing panel, all of whom represent U.S. government agencies that serve on the Special 301 Subcommittee, to introduce themselves. Maybe we can start at the end.
Good morning. My name is Omar Karawa from the Department of Agriculture. Thank you.
Good morning. Emily Blyman, Department of Health and Human Services.
Good morning. Maureen Pettis, Department of Labor.
Good morning, everyone. My name is Matt Lamberti. I'm with the U.S. Department of Justice.
Good morning. My name is Sung Chang. I am with the Office of the U.S. Trade Representative.
I'm Stephen Mitchell with the International Trade Administration, Department of Commerce.
I'm David Henry with the Department of State.
I'm Juan Chang, Department of Treasury.
Brad Greenberg, U.S. Copyright Office.
Good morning, Karen Ferreter, U.S. Patent and Trademark Office.
Thank you. The Special 301 Subcommittee of the Trade Policy Staff Committee is comprised of the agencies you've just heard from and chaired by USTR. It conducts the annual Special 301 review each year. The review is driven by stakeholder contributions and by contributions of Washington-based agencies and our embassy-based personnel around the world. The subcommittee is currently in the information gathering phase. On behalf of the agencies here, we thank you for the views, insights, opinions, and factual information that you will share with us today. The schedule of today's hearing is comprised of interested parties from foreign government officials, private sector interests, and civil society who responded to USTR's notice in the Federal Register published on December 28th and voluntarily requested the opportunity to appear at this public hearing. As a reminder, the purpose of today's hearing is to provide the Special 301 Subcommittee with additional information that we can use in deliberations that will lead to the publication of the 2019 Special 301 Report to Congress on or about April 26, 2019. This year, we have received public filings that address over 75 countries and many country-specific IP protection and enforcement issues that may negatively affect our bilateral trading relationships. Those filings are available to the public at www.regulations.gov. The docket number is USTR-2018-0037. The Special 301 report is the result of a congressionally mandated annual review of the state of intellectual property rights protection and enforcement in trading partners around the world, which the Office of the United States Trade Representative conducts pursuant to Section 182 of the Trade Act of 1974 as amended by the Omnibus Trade and Competitive Act of 1988 and the Uruguay Rounds Agreement Act. The provisions of Section 182 are commonly referred to as the Special 301 provisions of the Trade Act, hence the Special 301 report. Specifically, Section 182 of the Trade Act requires that the United States Trade Representative identify countries that deny adequate and effective protection of intellectual property rights or that deny fair and equitable market access to U.S. persons who rely on intellectual property protection. The statute requires USTR to determine which, if any, countries should be identified as priority foreign countries. Acts, policies, or practices that are the basis of a country's identification as a priority foreign country can be subject to the procedure set out in Sections 301 through 308 of the Trade Act. In addition to the statutorily defined priority foreign country designation, USTR created the priority watch list and watch list categories to assist the administration in pursuing the goals of the Special 301 provisions. USTR is also charged with developing priority watch list action plans where a country has been on the priority watch list without change for at least 1 year. The format of today's hearing is as follows. Each party will be allotted 10 minutes. Each person will start with 5 minutes of prepared statements, leaving 5 minutes for panel questions. However, we will remain flexible within the 10-minute period, making adjustments as needed. We will be watching the clock and will interrupt with a time cue when 1 minute remains from the allotted 5 minutes of prepared statements. The panel will hold its questions until the presenter concludes his or her statement. In some cases, we have prepared questions based on the written filings. In others, we will respond to your testimony today. In general, please keep in mind the purpose of this hearing, to provide information that the committee can use in satisfying the charge of the Special 301 statute, when conveying your testimony and responding to any questions that we may ask. Again, we will break for 1 hour from 12:20 to 1:20. And at this time, I would like to invite the Government of Bolivia to start us off. Welcome. Please introduce yourself and your organization for the record and begin your testimony.
Thank you very much. Thank you, all of you, to receive us today. We are here on behalf of the Bolivian government, the Bolivian state, the plurinational state of Bolivia. My name is Alejandro Bilbao La Vieja. I'm the DCM with the Bolivian embassy here to the U.S. I'm joining today by the ambassador Paulo Canedo from the embassy of Bolivia and the head of the Bolivian Authority of Intellectual Property, Mrs. Scarly Valeriano, and the head of the Department of the Economic Law at the Ministry of Foreign Affairs in Bolivia. And we are here to answer about your concerns on the 301 subcommittee. So, with ado to say, I will let the floor to Mrs. Alejandra to respond.
Hi, my name is Alejandra Gastelú. We will explain in detail the effort that our government has made to combat the infringement of intellectual property rights in its commitment to enforce the law. First of all, I would like to commend the activities that the government implemented to simplify the process of registration and enforce intellectual property for these years. First point, the administrative deconcentration. In September of 2018, the National Service of Intellectual Property expanded the attribution of its regional office in the city of Santa Cruz, where it presents a carries out large commercial transaction. The aforementioned office has powers related to registration and defense of intellectual property. The second point is the ratification and entry into force of the Hague Apostille Treaty. Bolivia signed the Convention of 5 October 1961, abolishing the requirement of legalization from foreign public documents, Hague Convention of the Apostille, in November 2017, and it entered into force in May of 2018. Thus, the procedures out by the right holders are faster, easier, and cheaper. It should also be noted that CENAPI plays an active role in terms of issuing documents under apostille parameters when granting intellectual property rights. Therefore, the direct beneficiaries are the holders of these rights. The third point is turning to another. It's necessary to mention a specific norm, the Administrative Resolution number 19/2016, because it regulates the internal procedure for action in case of infringement of industrial property rights. The aforementioned regulation provides effective and simplified procedures to the holders of rights, who must actively participate in the infringement proceedings, either on their own or through their representatives. As a result of the implementation of the aforementioned regulation, there's an increase in the request for infringement actions and precautionary measures. As a result of these sanctions, in the last year, 34,330 products were destroyed. The 4th point. The Customs Administration passed administrative resolution in October 4, and this norm regulates the distractions. Once the sanction for the distraction of goods by administrative process and is declared that execute without established deadlines. We have to mention the creation of the Vice-Ministry to combat contraband. This Vice-Ministry was created last year as a realization of the state's efforts to strengthen the protection of different areas of commerce. It should also be noticed that this Vice-Ministry has assumed the task of intelligence and operation against contraband, which is the main source of income of pirated and counterfeit goods. The permanent working group called Preventive and Educational Measures to Promote Licit Trade and Respect for Intellectual Property, where the Vice-Ministry against contraband constitutes the chair of the working group. It should be noted that in the last year, their tasks were focused in the infringement of industrial property and copyright, with emphasis on plagiarism and piracy. We want to mention just one little thing, that is the Binational Border Control Center, and the location is in the Desaguadero with Peru. We launched it as an integrated control facility where all border control agencies from both countries join forces. There is the CENAPI and the COPI, and they have the faculty to exchange information. Well, for all the mentioned, Bolivia reaffirms its commitment to protect intellectual property rights in accordance with the international instruments to which it's party. Thank you.
Do you have more testimony, or can we begin asking questions?
Yes, that's all.
Perfect. We'll start questions from USTR.
Thank you very much for joining us and for your testimony. We would like to learn more about the work of the Vice Ministry to find contraband activities. You just mentioned that the Vice Ministry does address counterfeit and pirated goods. What type of enforcement actions have the Vice Ministry taken thus far?
Buenos días. El trabajo que realiza el Viceministerio de Lucha contra el Contrabando es más operativo, hace trabajos coordinados con las entidades competentes como el CENAPI, AGEMED, aduana, en las fronteras con nuestros países vecinos, sobre todo fortaleciendo el trabajo principalmente con el Perú.
Good morning, and thank you for having me. The work of the MICE Ministry is more operative in nature, and it is coordinated with CENAPI, AGEMED, and also Customs and Border Control with our neighbors. And for example, we have been strengthening our work, especially with Peru.
Talleres de capacitación y sensibilización a las fronteras.
And then we also do training workshops and awareness workshops along the borders.
Thank you very much. The next question comes from the U.S. Patent and Trademark Office.
Thank you. Under Bolivia's Law 1134, the 2018 Bolivian Cinema and Visual Arts Law, how will film registration with the Bolivian Film and Audio Visual Development Agency, ADECIN, affect the enforcement of copyright for films that have not been registered?
Aparte de la ley, el CENAPI ha sacado un reglamento interno que está siendo implementado, pero lo vamos a complementar de manera escrita.
Besides the law, CENAPI has been working on internal regulations that it will soon be presenting in a written format.
Thank you very much. I believe that's all the time we have for questions. Next, I would like to call the Government of Bulgaria up. Thank you very much.
Good morning, everyone. Esteemed
Sorry. Let me first ask you to state your name and organization for the record, and then begin your testimony.
I was about to do that. My name is Ivo Konstantinov. I represent the Government of Bulgaria within the Embassy of the Republic of Bulgaria in the United States, in Washington, D.C., and Ministry of Economy of the country. I am grateful for the committee accommodating us and in our participation today. We are here on a very positive note as a testimony of the positive outcome of a good cooperation with the USTR, as our country last year was removed from the special 301 list, which we were extremely appreciative of. Our government has been running for many years, more than a decade now, and very highly organized interagency involving 9 government agencies, law enforcement, and the Attorney General's office, which is in permanent contact and cooperation with the USTR. Upon our removal from the watch list last year, there was also a list of recommendations issued by the USTR, which we have followed very closely in implementing in our country. And today I'm here as an example of a good outcome, and also to report on our progress after the removal of our country from the list, following the good recommendations issued to us from the USTR. First of all, one of the most important works we had to stress on our efforts, direct our efforts, was in the area of the Attorney General's office, and a point of contact and the chief prosecutor for IP-related cases was appointed, and regional prosecutors were designated especially for IP-related cases. The manual for the IP prosecution was mandated by the Attorney General with a normative act and distributed among the regional prosecutors. The law enforcement unit, especially the cybercrime unit, the IP enforcement part of our equivalent to the DHS in our country, it tripled its staff from 18 to 40, but especially tripled the staff prosecuting IP-related cases. The interagency on IP enforcement continues to meet on a regular basis, even after the exclusion from the list, to continue on following the policy of the government and the USTR recommendations for IP enforcement. Amendments to the Copyright Act were made also that were very necessary. We're working on looking for ways to use samples in court trials. It's a very complicated legally methodology, but we're finding ways to also use that. And a very special change was made where the IP prosecution unit of the main law enforcement body can now investigate individuals. There's very good reporting also on behalf of our country, even from last year or so, of sentences, IP crime-related cases, prosecutorial acts, convictions, penalties, and even imprisonments. There's 30 imprisonments, one of which effective and 29 conditional, related to IP breaches. Finally, I'd like to also express our high appreciation and positive evaluation of the trainings provided by the USTR and the US government to prosecutors and law enforcement that were extremely helpful, and we would encourage that they continue. And I'm here as an after case, before and after. We're the after case where we implemented your recommendations and were taken out of the list, but continue the work because this is important for us. And I remain available for your questions.
Thank you very much. We'll start questions with USTR.
Thank you very much for your time today and your testimony. The 2018 Special 301 report did not include Bulgaria on the watch list, as you said, but noted enforcement concerns, including high levels of online piracy, inadequate prosecution efforts, judicial delays, and insufficiently deterrent criminal penalties. Your submission indicates that Bulgaria has appointed specialized IP prosecutors on page 2, but also that enforcement activity was sharply down. New pretrial proceedings, prosecutorial acts, and convictions by 50% or more in certain categories in the first 9 months of 2018 compared to the same period in 2017. Can you please explain the seeming discrepancy?
A lot of the, especially internet-related IP breaches of entertainment and software content are now migrating to illicit software as service operations, always in service outside of the country. And in the area of entertainment content, there's a sharp decrease of torrent tracker usage in favor of streaming, also illegal streaming services. Always the servers located physically in foreign countries. And there's been a very serious success in IP enforcement in 2017, which has led to also decreased number of cases and of prosecutorial acts last year. That's the second reason.
Thank you very much. The next question is from the Department of Justice.
Thank you very much. So, hello. On March 29th, 2018, Ambassador Stoichev stated in a letter to Ambassador Lighthizer that the Bulgarian Prosecutor General shall, quote unquote, shall undertake in 2018 the improvement of procedures for investigating IP cases by, among other steps, adopting sampling in IPR cases. As you know, European countries and the United States typically use sampling in intellectual property cases. For example, if the police sees multiple servers loaded with terabytes of infringing material, police experts, prosecutors, and judges do not examine each work seized to determine if it is infringing. Rather, they rely upon a sample of what is seized for both the charging and the sentencing. So you just testified that Bulgaria is looking to use sampling in court trials. And in your written testimony, it looks like the Bulgarian government drafted a report last year regarding steps that could be taken to improve procedures for investigating IP cases, including sampling. It's not clear, though, whether or not Bulgaria actually did take concrete, specific action to implement that report and actually adopt sampling and other improvements in intellectual property enforcement procedures. Can you tell us if and when Bulgaria has taken specific concrete actions to improve the procedures for investigating IP cases, including sampling?
Mm-hmm. No, thank you. We're not ready with a written report, but doing a very complex legal analysis of how this can be utilized in prosecutorial activity. that would include blitz raids and sting operations, which is mostly the cases where we need to employ this instrument very much, and surprise searches. It's a complex procedure of obtaining court warrants, and the main challenge continues to be the expenses in time, storage, and personnel for what are extremely diverse types of materials taken during searches. Both authorities, the FBI DHS equivalent, the Cybercrime Prevention Unit, and the Prosecutor General's Office are in active process of improving this method in spite of heavy challenges, and the challenges are related to cost, time, and qualified law enforcement personnel. They are finding ways to do that, but not ready with a written report. It's a matter of a legal analysis of how this can be done.
All right, we have time for one last question, and it comes from the State Department.
Good morning. One of the concerns we described in last year's Special 301 report was inadequate prosecution efforts. You mentioned in your submission that the effectiveness of the judicial system when hearing cases in the field of IPR was improved. Could you elaborate a bit more on this? And is Bulgaria also considering instituting intellectual property courts?
I will have to come back on that, on the question of intellectual property courts, but directly answering your question, the manual for prosecution, the prosecutor's manual and Attorney General's issued and mandated manual for prosecuting IP-related cases has been a breakthrough in the improvement of efficiency in prosecuting IP-related crimes. That was the major step in the area that you are referring to. And as the Attorney General's Office by our country's constitution represents actually the country's judiciary, completely independent branch of government, there are also constitutionally mandated timeframes where improvements in prosecutorial technology have to be implemented, which we're working on.
Thank you very much for your testimony.
Appreciate it.
Thank you. May I call up the Government of Indonesia? Is a representative of the Government of Indonesia here yet? Thank you. Please state your name and organization for the record and begin your testimony.
Thank you. Good morning, Mr. Chairman, Sir David Lee, and U.S. colleagues. My name is Reza Pahlevi Hairul, Commercial Attaché of the Indonesian Embassy in Washington, D.C. I would like to thank USTR for allowing us to be present here today. As stated on the Special 301 Report 2018, the Government of Indonesia acknowledged United States concerns on intellectual property rights. And at this hearing, I would like to raise Indonesia progress on intellectual property right protections and enforcement for your consideration on the ongoing Special 301 review in 2019. Intellectual property right regime has been one of the top priorities for the Indonesian government for the past decade. Even we know there are some difficulty for us. The government of Indonesia have always taken and will continue to take concrete steps and action to enhance protections and enforcement of IPR, including among other amendment of IPR law, improvement of interagency, which is really difficult task, and internal cooperations. One positive milestone that is worth noting is the agreement between the Government of Indonesia and United States on the work plan on IPR concluded at the 17th Trade and Investment Framework Agreement meeting in Jakarta last year. Closing this 5 years negotiation signifies concrete foundations of IPR protections and enforcement joint effort between the two governments. As a follow-up, the Government of Indonesia is now optimizing the interagency IP task force under the leadership of the coordinating ministry for political, legal, and security to accelerate the role of the task force, related ministries, institutions such as the Indonesian National Police, the Ministry of Communications and Informatics, the Supreme Court, and the Ministry of Law and Human Rights have established an MOU. We also separately established a technical team to combat piracy for creative economy products under the coordination of Indonesian Creative Economy Body, whose role includes provisions of a public platform to report on pirated products. Within the period of 2015 to 2018, Bekraf had received substantial number of consultations and advocacy concerning the IP infringement in collaboration with the Motion Picture Associations of America. The National IP Task Force itself has met several times during the last quarter of 2018 and came up with a set of activities for the implementations of Indonesia-US IPR work plan in the coming years, including public education or awareness, legal framework strengthening, IPR enforcement and cooperation, as well as budgeting for those activities. With regard to patent law, in principle, the law number 13, 2016, aimed to provide robust intellectual property regulatory protections that demonstrate patent is a valuable property of its inventor and therefore must be protected. While amendment of the law will take a long time, we are addressing this with short-term actions with the implementation of Ministerial Regulation number 15 on July 2018, in which a patent holder who have not used or applied its patent in Indonesia could formally request a postponement in product manufacturing or utilization of the patent process for up to 5 years. We also building an online system to ease the process of application for patent holders. The government of Indonesia is also focused on the improvement of other areas in IPR protection, among other, the ongoing revisions of existing industrial design law, provision of online complaint and reporting mechanism for IPR piracy like websites, movie applications, and counterfeit products, of which there has been 93 cases of IPR handled by investigators during period of 2016 to 2018. And then initiating review of existing film law. Though the government of Indonesia strongly believes that Indonesian market is currently open to imported movie, that is shown with 94% of market share held by North American film. To sum up, I think it is Indonesia's interest to create a conducive environment for trade and investment, including IPR, and we look forward to closing work with you.
Thank you very much. We will begin questions with the International Trade Administration of the Department of Commerce.
Yes, thank you. This is a multi-part question, a three-part question. You mentioned a number of initiatives. Which specific IP reforms will Indonesia prioritize over the next 12 months? Will these involve changes to statutes or the development of implementing regulations, or perhaps both? And finally, is Indonesia committed to adhering to a transparent process for developing these policies that will allow for interested parties to submit comments on draft proposals prior to their implementation? Thank you.
Thank you so much. I believe that we have a working plan already, and Mr. David Lee was involved in that negotiation. And I think this is great momentum for us to closely work with the IPR protection and enforcement. And we, like I said, that we have optimizing the IP task force in Indonesia. Of course, there are some activities, probably including welcome any engaging with U.S. government or U.S. business community who rely on IPR right. And we welcome any discussion, and also we'll take any concern from U.S. business community. And again, the National IP Task Force right now is setting up budget and activities to be implemented soon in this 2019.
And if, as a follow-up, what about the transparency piece? Will stakeholders have an opportunity to comment on these developments before they're implemented?
I do believe, yeah, because like I said, we have a work plan in which both sides remain committed and agreed to intensify effort, especially in protecting IPR issue, including market access issues.
Thank you. The next question comes from the U.S. Department of Justice.
Good morning. The Creative Economy Agency, or BECRAF, announced several months ago that it would form a task force with the Communications and Information Ministry, the Intellectual Property Directorate General, the Prosecutor's Office, and the National Police to make it easier for people to report intellectual property violations in Indonesia to the right government institutions. A related issue is that people who do report intellectual property violations in Indonesia cannot easily see what happens with those reports. In fact, other than the listing of proceedings and the publication of decisions by the Indonesian Supreme Court, it is very, very difficult for the public in Indonesia, and also those of us here in other countries, to determine what, if any, intellectual property rights enforcement is occurring through Indonesia's court system. Could the BECRAF task force create a website to list intellectual property cases in the lower courts below the Supreme Court, including identifying the parties, the legal bases for the cases, and any penalties assessed?
Thank you, colleague from Justice. Yeah, again, that we have optimized the national task force, including BECRAF, and BECRAF has worked with the Motion Picture of America, and we also spared a technical team, like I mentioned before, to conduct IPR violations. So we will impose any penalties or detain goods who violate the IPR. But again, this is more work remain to be done. And we take note your questions, and probably we will answer in more detail in post-hearing brief. But again,
a website,
yeah, including the website, including the statistic and any information.
Great. Thank you for your testimony.
Thank you, Mr.
Thank you. Next, could we have the Government of Korea, please? Thank you. Please state your name and organization for the record and begin your testimony.
Good morning, everyone. Good morning, everyone. I'm Bo Hyun Nam, Director for Trade Affairs, the Ministry of Health and Welfare of the Republic of Korea. Concerning the recent Special 301 review, where PAMA requested the USTR to designate Korea as a priority foreign country, and BIO requested USTR to place Korea on the priority watch list. I wish to explain the Korean government position, focusing on drug pricing and reimbursement policy. Also, I would like to take this opportunity to help multinational pharmaceutical companies and the U.S. government to better understand the Korean pricing and reimbursement policies. Above all, the Korean government is aware that global innovative drug makers have made a significant contribution to fighting disease, such as rare and incurable disease, and cancer. We also understand that protecting intellectual property right is one of the most critical factors to encourage pharmaceutical manufacturers to develop new drugs. Comments submitted by the U.S. industry to the USTR on the 2019 Special 301 issued concerning intellectual property right include the following issues. First, Korea's pricing and reimbursement system. Second, Korea's premium pricing policy for global innovative new drugs. Third, other issues on Korea's health insurance system, such as an independent review process and the risk-sharing agreement system. Let me explain the Korean government position on those matters. First, unlike the healthcare system of the U.S., Korea has a public insurance system from which all citizens can benefit. Korea's public health insurance system has been making a substantial contribution to expanding patient access to medicine. The Korean government also sympathizes with the need to recognize the value of innovative drugs. In this regard, the Korean government is operating to properly recognize the value of innovative drugs. Accordingly, the Korean government ensures the value of innovative drugs to the maximum extent possible within the public health insurance system through the object criteria of clinical usefulness and pharmaceutical economic analysis. We believe that the intellectual property right of innovative new drugs are not infringed. Second, Korea's premium pricing policy for global innovative new drugs. Korea amended and on December 31, 2018, implemented the premium pricing policy consistent with the Chorus FTA, which is fair, reasonable, and non-discriminatory. In terms of operation of the amended premium pricing policy, there is concern that qualification criteria are so strict that U.S. companies cannot qualify for premium pricing and thus obtain practical benefit. However, only 2 months have passed since the implementation of this new pricing system, and it is too early to determine what outcomes will occur. If necessary, the Korean government will look forward to another opportunity in the future to seek mutually satisfactory outcomes on the operation of the system. Lastly, other issues on Korea's health insurance system. Korea is seeking to strike a balance between patient access to medicine and reimbursement for new drugs, introducing the RSA that provide a pathway for reimbursement listing of an anti-cancer and rare disease product without alternative. Out of a total of 16 companies receiving benefits from the RSA, 14 are foreign companies. 7 of the 14 are from the U.S. The Korean government plans to seek an opportunity in the future to discern opinions from the U.S. industry concerning its request that the scope of RSA application should be expanded. In addition, the Korean government has an institutional mechanism to properly seek the view of pharmaceutical companies through an independent review process. The U.S. industry has requested that the IRP should be applied even to the negotiation process for price with the National Health Insurance Service. The Korean government has continued to make clear that the price negotiation with the NHIS are not subject to the IRP, as drug price negotiations are made by mutual agreement between negotiating parties on equal footing. We reckon that what the U.S. industry has stated is not directly related to the infringement of intellectual property right, and their requests have been mostly reflected through the cross FTA. Therefore, we respectfully ask USTR to take into account comprehensive factors, including Korea's contribution to fair, reasonable, and non-discriminatory cross FTA, when finally drawing a reasonable conclusion. In the Special 301 report, the Korean government will endeavor to value innovative new drugs and to create mutually beneficial trading conditions. I would like to conclude by adding that the Korean government plans to actively recognize opinions of the industry in the future. Thank you.
Thank you. We will begin with questions from USTR.
Thank you for your testimony. Are there any companies, whether domestic or foreign, that have qualified for premium pricing under the new criteria of the premium pricing policy, recognizing that it has only been 2 months? But if you know of any foreign or domestic companies that have since qualified, we'd like to know. Thank you.
As I mentioned, just only 2 months have passed since the implementation of this new system. Basically, the Korean government position on this new system is to wait and see how things will go. If necessary, Korea is looking forward to another opportunity into the future, seek mutually satisfactory outcome or mutually beneficiary trading conditions on the operation of the system.
All right. Thank you for your testimony.